Yeah, a very dynamic situation down in Pietermaritzburg, and it's all got to do, really, depending on which side of the fence you sit on here, has to do with this story, these protests we're seeing around the country. The Constitutional Court is today going to hear former President Jacob Zuma's application to have his prison sentence overturned. Zuma currently serving this 15-month sentence after he was found guilty of contempt of court. Now, as a result of that, Masego Rahlaga, we're going to talk about the CONCOURT today, but many people saying, we've seen the hashtags, free Zuma, let Zuma out, etc., etc., as a result of this court decision by this apex court, which is now spilling over into looting and criminality and rioting. Let's call it what it is. But today, the focus again on the court for the former president to ask them to do what?
Well, he's asked them to overturn their decision to send him to prison for 15 months. But not only that, Gareth, the former president is also saying that he doesn't think that he was in contempt of court. Now, you must remember why the Constitutional Court came to that judgment or came to that decision. It was, of course, a split judgment, although the majority court decided that he's in contempt. And actually, all of them said that he is definitely in contempt. While the minority said he shouldn't go to jail, the majority said he should. So how they came to this decision, you might remember, the former president did start his testimony at the State Capture Commission of Inquiry. You'd remember that there were some questions that he sat on the stand for a couple of days. I think at one point for the first day that he was on the stand, he spoke for hours explaining why he should not be looked at for corruption pertaining especially to the Gupta family. Fast forward, the former president decided that he would not continue his testimony at the State Capture Commission of Inquiry, even after he was given summons to do so. He, for instance, had more questions that he needed to answer to because as the days went at the State Capture Commission, he was mentioned quite a couple of times more by those who testified. He refused to do that, and instead he applied for the Deputy Chief Justice, Raymond Zondo, who is also, the one sitting at the State Capture Commission of Inquiry, or who is the inquiry chair, to recuse himself, complaining that he is biased and that he would be unfair against him. That's the former president. But of course, the Constitutional Court then, the Zondo Commission applied at the Constitutional Court to have him compelled to testify. And after the Constitutional Court said that he should testify, he still didn't appear at the Zondo Commission of Inquiry. And therefore, this is why he was found to have been in contempt of court. And the entire Constitutional Court, all the judges there agreed. But in his application to the Constitutional Court about 2 weeks ago to have him rescind their decision about his 15-month jail term, he also mentions that he feels that he actually wasn't in contempt of court. He also feels that they should actually give him a chance to explain himself. He said that them sending him to prison is actually tantamount to a death sentence. He said because he's 79 years old and he's got a few illnesses, and sending him to jail would basically be sending him to die. The Constitutional Court obviously responded by saying, we'll hear your case. That is happening today. The former president also saying that it was unfair that he was, taken to jail without a fair trial. He's saying that they should have given him a trial. But of course, the question here, Gareth, is why didn't you make all those arguments when the Constitutional Court gave you that opportunity in February and in April? You didn't hand in your answering affidavits and all the papers that your lawyers have to hand in. Instead, you decided to be AWOL. So that's why we find ourselves here today.
And also go to the Pietermaritzburg High Court, hoping for a different outcome, which, as we know, the High Court is a lower court. We're never going to go against the Constitutional Court. Unpacking for us beautifully and lining up my next interview fantastically is Masego Rahlaga. Let's now speak to a legal expert from Makangela Mtungani attorney, Sinao Makangela. Good morning to you, Sinao. It's a huge pleasure to have you on the show today. So the CONCOURT is going to give the former president a chance to speak today, to hear, as Masego says, his side of the story. But he's had chances before to put forward his side of the story. How do you see today playing out? And more importantly, could we see a case where the former president is released from prison, do you think? Sinawa, I think you've got your microphone muted. Could you maybe just unmute for me quickly and then come back to me with your answer?
I'm sorry. Good morning. Can you hear me? Good morning, Gareth and the viewers at home. I think everyone in the country is waiting in a bated breath to see what the CONCOURT has to say to its own judgment. And actually, it's not really to overturn its own decision, but rather is to reconsider, because this is not an appeal, but rather a rescission application, which is brought in terms of Rule 29 of the Constitutional Court rules. And there are 3 grounds upon which a litigant, that is in this case the former president, can just bring his application to say, look, CONCOURT judges, you committed some errors, whether the judgment was granted in error or was granted in my absence. Secondly, there's an ambiguity in the judgment that you have granted. And we all agree that there is nothing ambiguous. The CONCOURT directed that the former president must go straight to jail for 15 months, so that one is clear. Thirdly, that there must have been a mistake that has been identified to have been common between all the parties. The parties would mean now the former president and the commission, and possibly those amicus that have been forming part of this litigation. But there is no such a mistake. We now know that there is no ambiguity, there is no mistake, but he is arguing strongly for the first ground that the judgment was granted in his absence. Whether that will hold water, we'll see today when his lawyers advance that argument. However, for the side of the commission, they argue strongly that he has been given enough time to come. He was invited several times, would respond by writing letters. Well, they take it to an extent that he showed the CONCOURT judges some middle finger when he was called to come and explain the side of the story. Even when the court had to grant the judgment of the contempt of the directing him to go and appear before the commission. Now, he did not comply with that judgment, as Dumelo was saying. And now the court had to say, look, let's put an end now to a disrespect of the authority of this institution, which is the highest court in the land. And then the court now found him guilty of this contempt, and all judges agree, in their majority. In fact, all judges agree on the contemptuous behavior. But where there was that dissent, however, what is the law now is that which has been agreed to by the majority, that he must go directly to prison to serve his sentence.
So now just help me understand what we could hear from the president today. Masego was referring to this, is that he does have, according to him, health complications. We don't know what those are. And let's call it his advanced age, for someone of his age to be imprisoned. How could the CONCOURT view something like that once he puts that argument forward? In the last minute or so I have with you.
Well, that cannot be the ground for the rescission. As I say, in law, the grounds for rescission is that there must have been an error. That's why the court will have to tell whether he was absent when he was invited and did not come and did not use that opportunity to advance his case. But it's just serving some kind of a mitigating factor. He's trying to put more weight. But one of the persuasive points that I could see in his argument was when he quoted the Supreme Court of Appeal judgment in the case of Mr. De Beer, which was delivered 2 days after the CONCOURT judgment. But the SCA was faced with a similar situation, but what it opted to do was to direct the matter to the NDPP for the decision to prosecute Mr. De Beer. It decided not to impose a sentence of imprisonment to Mr. De Beer, who wrote a letter to Mandi Samaya, the SCA, the president there, together with all the judges, insulting them. So it may serve as a persuasive point, though, not to say the CONCOURT as well will be obliged. As I say, the argument will be very interesting, because there are many issues that they are raising as well on their side, the commission, to say, look, this is the person who has been contemptuous from day one, from the commission to the CONCOURT. So there is nothing new. He knew everything. He knew what was at stake. He was represented throughout all this period. He knew that he should not comply with the CONCOURT order. He would be facing some kind of punishment. And his conduct, they say, well, he deserved this kind of punishment of direct imprisonment of 15 months.
Well, I appreciate your time in speaking to us, legal expert Sinao Mankangela, joining us. That proceeding set to get underway around about 9 o'clock this morning, all be done virtually because of COVID-19 restrictions. Masego Rahlaga is our reporter following that today.